Get ready for the dictation. Start. It is further contended that recital made in clause 8 of the deed in question do not make it revocable. In fact, entire right of the owner/donor has been transferred in favor of the donee, who has been authorized to enjoy all the rights of the property being owner. There is no illegality or error in the order passed by the stamp authorities. Petitioner cannot escape from his legal duty to pay the required stamp in execution of power of attorney. Considered the submissions advanced by learned counsel for the parties and perused the record on board. Questions for consideration in the present matter is as to whether deed in question, power of attorney dated 15/12/1994, is irrevocable and can be treated as an conveyance for the purposes of imposing the stamp duty under Article 48 EE of Schedule 1B of the Stamp Act. Power of attorney dated 15/12/1994, Annexure Number 1, succinct the authority of the attorney who has been authorized not only to take care of the property in question but also to execute the lease deed and sale deed in favor of third person on behalf of principal. Subject matter of power of attorney is flat number 5, measuring area 1106 square feet, consists of 2 bedroom, 1 drawing/dining room, 2 latrine bathroom, 1 kitchen and store and veranda/balcony. Aforesaid flat is situated at the 3rd floor of house number 112/351. Stamp authorities have assessed the market value of the aforesaid flat to be rupees 5 lakhs and accordingly imposed the deficiency of stamp to the tune of rupees 72,444 along with penalty amounting rupees 2,556, total amount of rupees 75,000. They have treated the aforesaid deed as an irrevocable deed by which donee has been authorized to transfer the immovable property. Accordingly, stamp duty has been imposed under the provisions of the Stamp Act. As per submission made by counsel for the petitioner by virtue of clause 8 and 9 of the power of attorney dated 15/12/1994, donee has been authorized to act on behalf of donor and deed has been made revocable and right to revoke is reserved with the donor. Submissions as made by learned counsel for the petitioner has been contradicted by the learned standing counsel and contended that recital made in clause 8 will not frustrate the applicability of Stamp Act, and the whole reading of the deed in question suggests that it is irrevocable authority given to the attorney to enjoy and transfer the subject matter of the deed in question. For the purpose to draw the intention of donors in the execution of power of attorney, recital made in clause 8 and 9 of the deed should be examined in the light of the provisions as enshrined under the Stamp Act. For the ready reference, averments made in clause 8 and 9 of the power of attorney dated 15/12/1994 is reproduced hereunder. Clause 8 and 9 of the power of attorney succincts that in case of dissatisfaction with any work of attorney, executants, donors possess the right to revoke the general power of attorney and all the acts done by attorney with respect to the flat will be understood and done on behalf of donors and will be accepted and admitted by them. Relevant provisions of Article 48 of Schedule 1B of the Stamp Act with UP Amendment is reproduced hereunder. Before discussing the merits of the case, the nature and scope of the power of attorney is required to be discussed first. Section 1A and Section 2 of the Power of Attorney Act 1982, since the scope and nature of the power of attorney, which enunciates that power of attorney includes an instruments authorizing a particular person to act for and in the name of a person who has executed it. A power of attorney holder may, however, execute a deed of convenience in exercise of power granted under the power of attorney and convey title on behalf of grantor, and every such instrument and thing so executed and done shall be as effectual in law as if it had been executed or done by the donee with the signature and seal of the donor. Thus, it is clear as held by Honorable Apex Court in the case of Suraj Lamp that power of attorney is not an instrument of transfer qua any right, title or interest in an immovable property. Stop.